reasonable distance. The vehicle then drove through the right side door, disregarding a traffic control device in order to illegally pass the vehicle it had been following.
All right, let's set the scene. We're about to witness Judge Fleischer, and trust me, this man does not play games. Right out of the gate, we've got a DWI stop with all the classic red flags. Dazed driver, avoiding eye contact, red watery eyes, and the unmistakable odor of alcohol. But here's the kicker. This driver was following too close.
The officer initiated a traffic stop by activating lights and siren. On approach, the defendant appeared dazed, confused, and had to be purposely avoiding eye contact. When the defendant faced the officer observed red, watery eyes and a strong odor of alcohol emanating from the defendant's breath. The officer asked the defendant to exit the vehicle, and the defendant stumbled as he exited. The defendant denied consuming alcohol and illegal drugs. The defendant stated he had an injured ankle. The officer requested the defendant to perform SFSTs. They were 6 out of 6 for the HGM, 3 out of 8 for the walk and turn, and 2 out of 4 for the one leg stand. The officer confronted the defendant with observations of intoxication, and the defendant admitted to consuming an unknown amount of vodka an hour earlier. The defendant refused the breath specimen, and the officer arrested the defendant and then located a white cup containing brown liquid smelling distinctly of alcohol in the driver's cup holder.
Alcohol in the car.
And a blood warrant was obtained and drawn at 3:47.
Mr. Benton, it's damn elementary that you're not to have alcohol in the car while you're driving. And if it's proven in trial, it's a minimum of nearly a week in jail. Do you understand?
Okay.
As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm putting now an additional restriction on your license. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, if you're caught consuming alcohol, if you're caught consuming illegal drugs, I will revoke your bond, put you in jail. There will be no more PR bonds for you. Do you understand? Does he have a valid license to drive?
No, Your Honor, it looks like it was suspended as a part of a gun investigation, Brazoria County DWI.
Does he have an open DWI now?
I'm looking that up in Brazoria County.
That would be great, because I'm going to load him up with conditions in the event that he has an open DWI or something similar. Please. You do not have a Texas driver's license that's legal to drive, Mr. Benton. You will be signing an affidavit with me today promising me you're not going to drive. I don't give a rat's behind what you have to do in this life. If you drive, I can have a contempt hearing. Every time you drive, you can be facing 180 days. I can slap it with you, throw your ass in jail. You drive on multiple occasions, I can stack it. Do you understand?
Yes, sir.
If you have a problem with drugs or alcohol, now is the time for you to address it. Because if you don't, I will do it for you. And I promise you're not going to like the way that I do it. Do you understand?
Yes, sir.
And Your Honor, I don't want to interrupt the court. I was able to confirm there is an open charge. There's not a conviction yet.
There is an open DWI and okay.
It predates this bond.
As a condition of your bond, on one ankle, you will get a scram monitor. So I know that you're not consuming alcohol. On your other ankle, you will get a GPS monitor, and I'm giving you a curfew of 7 p.m. to 7 a.m. You violate any of these conditions, and I don't care what your excuse is. I don't care if you consume mouthwash. I don't care if it's toothpaste. I don't care if it's a tequila lollipop, whatever the hell it is. You blow hot on any of the devices, you will go into jail. And because you already have an open DWI, I'm going to make your bond extremely high. Do you understand?
Yes, sir.
Are you 100% positive that he has an open DWI now?
Whoa, did he just say, I'm revoking your bond? That's the nuclear option, folks. Judge Fleischer was about to give this guy conditions. Scram monitor, GPS, curfew, but the moment he hears there's an open DWI, he flips the script. This is what we call judicial discretion in action. The judge is sending a crystal clear message. You don't get a revolving door in my courtroom.
I'm seeing it reflecting in his TCIC history, Judge, and it's also reflecting as an ALR suspension for refusal on.
Got it. You know what? I'm just going to put you in jail now. I'm revoking your bond. I'm not giving you another PR bond. This is not a revolving door, Mr. Benton. You're going into custody now. All the conditions that we have now will apply. And I'm telling you, any conditions that you violate, do you understand? Goes with you. Can you please appoint him a lawyer?
I'm gonna hire a lawyer.
For now, I'm putting you in jail and I'm appointing you a lawyer. You can get one later on if in the event that you bond out. And if you can please file the guardian and all paperwork.
Yes, Judge, it's in there.
Okay. All right, you ready?
Yes, Judge.
Let's roll.
Bottom of 2, top of 3, Ohana. Ohana, is that you? Come on up.
Good morning, ma'am. Ma'am, you're charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. It also appears that you're charged with interference with the duties of a public servant. On that one, you're facing up to 6 months in jail and or a $2,000 fine. Okay.
On July 10th of 2026, at approximately 3:19, at approximately 17:19 hours, officer arrived at 6101 Richmond Avenue in Harris County. The complaining witness works at a leasing office where the defendant lives. The complaining witness stated the defendant entered the office upset with the technology for the app used to access the property. The complaining witness told the defendant the office was closed because it was 5 p.m. The complaining witness said the defendant ran into the office and grabbed the phone. The complaining witness advised the defendant to leave and ended the call the defendant was trying to make. The complaining witness stated the defendant became aggressive, called complaining witness a bitch, and picked up the phone and was swinging it by the cord. Defendant then pushed the complaining witness with her left hand. The complaining witness grabbed the defendant's right hand to prevent herself from being assaulted. The complaining witness's coworker walked in and attempted to defuse the situation, and the witness began recording a video upon her arrival. The witness asked the defendant to leave, and the complaining witness and the witness began to escort the defendant out. Defendant turned and began swinging her black purse at complaining witness multiple times with her right hand. The witness was between defendant and complaining witness, and the defendant pushed the complaining witness in an attempt to get close to the complaining witness. The complaining witness stated the purse struck her left arm twice. The complaining witness tried to block the purse from hitting her and was struck again, which caused pain and redness. The complaining witness is 5 months pregnant. When the officers attempted to detain the defendant refused multiple commands to put her hands behind her back. As officers tried to detain the defendant pulled away multiple times and put her arms underneath her chest. After cuffing the defendant's right hand, the defendant continued to pull away.
Ms. Bohan, I'm going to find that there's probable cause to go forward with your case. You were very lucky.
Okay, pause. This case just got way more serious than it looked at first glance. Assault causing bodily injury, but the victim is 5 months pregnant. Judge Fleischer is basically telling this woman, you are incredibly lucky you're not facing a felony right now. Because in Texas, assaulting a pregnant person, that's a 3rd-degree felony with serious prison time.
That you were not charged with assault of a pregnant person, which is a felony offense. As a condition of your bond, I'm ordering you not to go back to this leasing office and not to have any contact with the complaining witnesses in this case. If you violate these conditions, I will put you in jail. There will be no more PR bonds for you. If you understand, ma'am, I'm not asking much from you. I just want my town protected, and I'm going to do everything in my power to do it. You violated, I've just put you in jail. You understand me? We will have bond conditions created for you to sign, promising us that you will not have any contact, not be in possession of any weapons, not to go back to this leasing office. Do you have the ability to hire a lawyer, ma'am? Do you have the ability to hire a lawyer?
Other than that,
Are you employed at this time?
no, sir.
Okay. We will appoint you a lawyer today, ma'am. Like I said, I'm not asking much. Do you understand? Okay. For now, we'll have you sign a reset, and then we'll have you take a seat in the jury box while we get your bond conditions and find you a lawyer. Please, ma'am. So, yeah.
Judge, top of page 5, Dixon.
Do you mind filing conditions on her?
Yes, Your Honor.
So essentially, the way I hear, Every time we have conditions where someone's going to be monitored, I'm going to have Michael do the conditions. When a person's not monitored, like I'm monitoring as far as drugs or alcohol or GPS monitoring or scram like that, he'll take care of that. In that respect, she's not monitored. We just need bond conditions, no contact, no weapons, no going back to the leasing office, please.
So it looks like there are some viable right here, Your Honor,
Let me see.
but it does have an additional condition on there that we could cross out.
Oh, I see. Yeah. Okay. We'll just use those.
To the court.
Yeah, that's fine.
Thank you, Your
Yeah,
Honor.
we'll use that.
Judge, this is Dixon on track two.
Got it. All right. Good morning, Mr. Dixon. So you're charged with driving while intoxicated. It is elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. It's like you're also charged with unlawful carrying of a weapon in the 496. Okay.
On July 10th, 2026, officer was on patrol on I-45 near Beltway 8 and observed a blue Hyundai failing to maintain a single lane and speeding. The officer placed the Hyundai at 61 miles per hour in a 45 mile per hour zone. The officer observed the Hyundai use its left blinker but changed lanes to the right, almost wrecking another motorist. The officer activated emergency lights and sirens to conduct a traffic stop, and upon driver's side approach, officer detected a strong odor of alcohol emitting from the defendant's breath and inside the vehicle. He also observed the defendant to have red, bloodshot eyes. And officer observed a cold, unopened 6-ounce Shields beer can in the cup holder and another can open and half empty on the floor. Officer also observed a black 9mm handgun on the passenger seat without a holster. Officer asked the defendant to exit the vehicle to conduct SFSTs. The HGM was 6 out of 6, including the vertical gaze nystagmus. The walking here was 8 out of 8, and the one leg stand was 3 out of 4. The defendant consented to provide breath, and officer ran a criminal history on defendant and found defendant to be a convicted felon. Defendant was transported to Harris County Jail. Officers waited 15 minutes and they conducted a breath test, which came back at 0.229 and 0.223.
Does he have a license to drive?
This license is currently eligible.
It's eligible? Okay, thank you. Mr. Dixon, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. When I say illegal drugs, this includes marijuana. You are not allowed to use it. If you test positive, then I will revoke your bond and put you in jail. Because of the high alcohol and the allegation that you have alcohol in the car, I'm now placing an additional restriction that you are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, then I will revoke your bond and put you in jail. Do you understand? I send notice to DPS in Austin so that every police officer in the state knows if they pull you over, that car doesn't have an interlock, they will put you in jail. If I have to put you in jail, there will be no more PR bonds for you. This is not a revolving door. Do you understand? What is your question?
So currently I work for a mortuary, removal technicians, and it requires me to drive.
Any car that you drive must have an interlock on it. It doesn't matter whether it's work, it doesn't matter. It's just any car that you drive must have an interlock. Do you understand?
I understand.
Great. We are going to reset your case to give you time to hire a lawyer. This is not a negotiation, man. I'm just putting conditions that I'm thinking and hoping will protect our city. If you show me that you're just not going to comply with it, there's only one place I have for you. I'm not asking much from you. I want my city protected. I'm going to do everything in my power to, you understand? All right. I'm going to have you sign a reset. We will have you take a seat while we get your bond conditions. Once you sign them, at that point, you'll be free to go. So, Michael,
Yes.
on all DWIs, no alcohol, there are no drugs and no random testing, please. Make sure that there's random testing for all DWIs, okay?
All right, Judge, next is Pop-Up 7, Garza, come on up.
Counsel, do you have an arraignment?
No, Judge.
No, Your Honor, it's okay.
With the PCI removal.
Okay, let me do the arraignments and then
Sir,
I'll hit
Do you
you.
mind if I just stand here just to?
Yeah, of course, sure. Garza, come up.
All right.
All right, good morning, Mr. Garza. So you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On July 12th of 2026, approximately 1 a.m., officers were dispatched to a dispute with a possible firearm at the 1300 block of Kentucky Street in Harris County, Texas. The officer observed 7 to 8 people standing on the side of the road with the South Houston Police Department officers, and the officers observed one juvenile female who was 14 years old, assume a fighting stance, both fists raised in an attempt to fight one of the SHPD officers. The officers advised juvenile she would go to jail if she continued. The juvenile screamed, "I don't give a fuck," and the SHPD officer attempted to arrest the juvenile. The defendant quickly approached and placed both his arms on the SHPD officer's torso, impeding the officer's arrest. The responding officer grabbed defendant's arm towards the ground, causing defendant and the officer to fall, causing officer to sustain a laceration to his left elbow. This caused pain. The officer was treated by EMS at the scene.
Wow.
Wait. Did the judge just say wow? That's the prosecutor's worst nightmare. Judge Fleischer just realized they didn't charge this guy with assault on a peace officer. Let me break this down. The defendant grabbed a cop during an arrest, caused the officer to fall, and the officer got a laceration. That's textbook assault on a peace officer, a third-degree felony. But the prosecutor only filed interference with a public servant, a Class B misdemeanor.
They didn't charge him with assault on a peace officer.
Does not look like it.
Mr. Garza, I'm going to find that there's probable cause to go forward with your case. Do you think alcohol or any kind of dope played a part in this? What time of day or
It was
night
1
was
a.m.,
this?
so I don't know if you don't have it in here that alcohol.
Mr. Garza, I'm not going to place any conditions on you now, but if you show me that you're a danger to my city, it's just not going to go well for you. Do not pick up any new cases. Do you understand me? We're going to reset your case to give you time to hire a lawyer. So I'm going to have you sign a reset and then we'll get you out of here. When you come back, please have a lawyer. Come on.
All right, Judge, top of 8, Hubert.
Hubert. Did you get it?
Yeah, I got it.
Okay. All right. Good morning, Ms. Hubert. Ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On July 10th of 2026 at 4 p.m., an officer dispatched to a Hobby Lobby at 10955 FM 1960 Road. The defendant, who was ID'd by her Texas driver license, was observed on camera of the business and in person in possession of multiple items in the jewelry section of the store. Complainant stated that the defendant bought some items at the checkout line, but did not attempt to pay for the jewelry and merchandise that was in her possession separate from the transaction. The complainant said that the defendant passed all points of sales with the jewelry and merchandise and then was detained near the first set of exit doors at the store. The total return was $154.
Got it. Okay. Ms. Hubert, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you're ordered not to go to any Hobby Lobby whatsoever for any reason. Do not pick up any new cases. Otherwise, I will revoke your bond and put you in jail. There will be no more PR bonds. Do you understand, ma'am? Do you have the ability to hire a lawyer? Okay, we will give you time and have you sign a reset. We will have you take a seat while we get your bond conditions. Once you sign them, at that point, you'll be free to go. Yes, ma'am, please.
All right, Judge, next is bottom of 11, Ortiz. Come on up.
You speak English, sir? Mr. Ortiz, you're charged with unlawful restraint. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, and you have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On April 12th of 2026 in Harris County, Texas, an officer was dispatched to a disturbance call. The officers arrived at the location and heard a woman scream. Complaining witness opened the door and complaining witness stated she had been in a dating relationship with the defendant for 6 years and they lived together. Defendant got upset because complaining witness came home late. Defendant broke the case in the living room and stated, "We both going to jail." Complaining witness stated she hit defendant to defend herself. Complaining witness tried to call her coworkers to ask for help. Defendant took her phone and smartwatch from her. The defendant prevented her from getting to the door when police arrived by physically restraining her. The defendant held her mouth while she was screaming for help. The complaining witness felt pain from the altercation. The officer found complaining witness's phone and smartwatch in defendant's pocket. The officer observed injuries on complaining witness, including a bruise on her wrist, a bruised lip, and a bloody left ear. The officer spoke to witness, a neighbor, who stated he heard a bang and loud arguments.
Mr. Ortiz, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol or illegal drugs. You will be randomly tested. This includes marijuana. If I find that you're consuming anything illegal, then I will revoke your bond and put you in jail. You were also ordered not to have any contact with this person, not to be in possession of any weapons. When I mean no contact, I mean no contact of any kind. Social media, phone calls, text messages, going to where she lives, going to where she works. You're not to go within 1,000 feet. You understand? If you violate this, I only have one place for you. You have already missed court once. Every time you miss court, I will triple, quadruple, quintuple the bond. Do you understand? Do you have the ability to hire a lawyer? We will give you time. I'm going to have you sign a reset. You'll get with Michael for your bond conditions, then you'll be on your way. Don't have contact. Don't pick up any new cases.
All right, Judge, next is bottom of 12, Ramirez. Go ahead and sign.
All right, Mr. Ramirez, you're charged with driving on a suspended license. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On July 10th, 2026, in Harris County, Texas, an officer conducted a traffic stop on a motor vehicle for operating a motor vehicle on a toll road while prohibited. The defendant stated that his driver's license was suspended and that he did not have insurance on the vehicle, which the officer confirmed.
Mr. Ramirez, I'm going to find that there's sufficient probable cause. I'm ordering you now as a condition of your bond not to drive. You will be signing an affidavit promising me you're not going to drive. I really don't care what you have to do in this life. You cannot justify getting into a car for any damn reason. Not only that, you're on felony probation. When you're on probation, you're supposed to live as if you have a halo. Otherwise, it's very possible they file a motion to revoke. Do you understand? It would probably be a good idea for you to hire a lawyer as soon as possible. I'm not going to talk with you about this.
I have an attorney already.
Oh, you do?
Yes, sir. I don't know, you're not here, just Marco, Roger.
Adroge? Okay. Do you know if he's going to be here today?
Supposed to be here already.
So what we'll do is I'm going to prepare all the paperwork. We are going to have you promise us that you're not going to drive. We will have bond conditions created for you to sign. At this point, we will have you sign a reset. I'm going to have you take a seat in the jury box. We'll wait till see if Mr. Adroge shows up. If not, we will just give you a normal reset to hire a lawyer. Come on, don't drive. I don't care what you have to do.
Judge, is that going to be state's bond conditions?
Yeah, do you mind filing no driving, please?
Yeah.
All right, Judge, top of 13, Rivera.
You speak English, ma'am?
A little.
Would you prefer a translator?
Yes.
Spanish translator, please. All right, please. Toma acepta, por favor.
Top of 14, Salazar.
I didn't know.
Good morning, Mr. Ruiz.
Good morning, Your Honor.
Ruiz. Or Salazar. We're doing Salazar, right? Is that who it is? Salazar. All right. Good morning, Mr. Salazar. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On July 12th, 2026, at 1:02 a.m., an officer captured on radar a motor vehicle going 48 miles in a 30-mile-per-hour zone on a public roadway in Harris County, Texas. The officer conducted a traffic stop and noticed slurred speech, glassy, bloodshot eyes, and the defendant stated he had 2 small beers. The SFSDs were conducted, and they were 6 out of 6 on the HGN, 7 out of 8 on the walking turn, 3 out of 4 on the one-leg stand. The DIC was red and the defendant conducted a blood draw at 2:10 a.m.
Okay, any prior DWIs?
There was no criminal history on it.
And then license, do you guys,
License and valid, regular license.
yeah. Do you mind checking to Miss Gilbert, please? This is Mr. Salazar.
His driver's license is eligible.
Wonderful. Mr. Salazar, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If I find that you're using alcohol or drugs, you will go to jail. I will revoke your bond. You understand? All right. Because you have a lawyer, I will waive your appearance. You don't have to wait your time come to court, but you must stay in touch with Mr. Ruiz. He'll tell you if and when you have to come back to court. Do not pick up any new cases. You understand?
Sir.
Okay. We'll have you sign a reset conditions and then you guys are on your way.
Thank you, Judge.
Thanks, guys. Good to see you, Mr. Ruiz.
Bottom of 16, Stahl.
Good morning, Mr. Stahl. Sir, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Your Honor, I just want to confirm this is Straw, S-T-R-O-U-G-H.
There's no R,
It's S-T-O-U-G.
S-T-O-U-G-H.
We'll have that connected.
Error in our system.
Very good.
Okay, well, all right,
Thank you.
not a problem.
On July 10th, 2026, in Harris County, Texas, an officer dispatched to a minor accident. The officer made contact with the defendant who stated to the officer that he was operating his motor vehicle when he struck another vehicle that was parked legally on the public roadway. The officer noticed red glossy eyes, a thick slurred speech, and an odor of alcohol from the breath. The SOSTs were conducted and they were 6 on the HGM, 7 out of 8 on the walk and turn, and 3 out of 4 on the one mic stand. The DSC was red and he consented to a blood draw.
Okay, does he have a license to drive? Do you mind checking on Mr. Stahl?
Your Honor, there was a previous DWI also.
Sure, this I do know.
His license is currently eligible on.
It is?
Yes.
Okay. Mr. Stahl, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If I find that you're using, I will revoke your bond and put you in jail. Because this is a second offense, I'm ordering you not to drive any vehicle that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have one, you will go to jail. Do you understand? We are going to reset your case to give you time to hire a lawyer. I'm going to have you go sign a reset. We will have you meet with Michael for your bond conditions, and then you'll be on your way.
What if I can't hire? What if I have somebody to work, but
So this life is not about how much money you make. It's about how much money you spend. Mr. Stahl, you have number 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, now number 18. In all of those cases, how many times have you gotten a court-appointed lawyer? It's now time for you to start working on it. Do you understand? Right. I'm gonna have you sign a reset. We'll get you started with your paperwork and then we'll see you in a month.
All right, Judge. Top of 17, Treadwell. I'll sign in just a minute. 1 second.
Password expired. So I'm gonna have to restart everything now. So just give me 2 minutes. Okay, I think I'm back. All right, Victoria, you ready?
Yes, Judge.
Let's do it.
Top of 17, Treadwell. Come on up.
Guess who's back? Back again. Ms. Treadwell, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On July 11th of 2026, an officer dispatched to the 2700 block of Eldridge Parkway, Houston, which is in Harris County, Texas. The location is the complaining witness, who was a loss prevention officer of Target, the defendant was seen entering the store and going to the grocery side and making a selection of women's nails and personal clothes care. The defendant was then seen putting the selected items and head toward and then heading towards the guest services. When the defendant was denied the return, she proceeded to walk past all points of sale. She headed toward guest services, tried to get a return, and when the defendant was denied the return, she proceeded to walk past all points of sales. Target Asset Protection attempted to stop the defendant, but she ignored all verbal commands to return to the security office. An officer saw a defendant walking in the parking lot, detained her, and brought her back, where she was positively ID'd. The total was $130.21. The Target Loss Prevention found more items as well, bringing the total to $136.90.
Ms. Treadwell, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to go to any Target for any reason whatsoever. Ms. Gilbert, there is a motion to revoke that's been filed in Ms. Treadwell's case. Do you mind signing it, please?
Yes, Your Honor.
You were on probation for a DWI in this court. You have picked up a new case. Guess what happens now? Correct. Exactly. You're not supposed to pick up any new cases. There are other violations in the motion as well. I am now revoking your bond. You will go into custody.
Judge, we have the interpreter. Are you-
Okay. Hi, Luis. You ready? Yeah.
Page 13, Rivera.
Three. The bond's at 7502 now, so 10,003. Please. Just on the motion case. Yeah. All right. Good morning, Mr. Rivera.
Good morning.
Ma'am, you're charged with assault causing bodily injury.
Right.
You were facing up to a year in jail and or $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
On July 20th of 2026, in Harris County, Texas, an officer responded to a welfare check at 19220 Cedar Lane. The complaining witness stated that her and the defendant had been in a verbal argument of complaining witness spanking the defendant's child. The complaining witness is stating the child's father, and the father allows this discipline. The two began hitting each other with closed fists. The defendant stated multiple people attempted to break up the fight. The victim stated that she and the defendant were briefly separated when the defendant grabbed a metal paper towel dispenser and hit her in the head, causing a pain of 10 out of 10. The victim stated that she was also hit on the left arm, but stated she could not give a pain level due to being hit in the head, hurting very badly. The officer observed scratch marks on both parties that would be consistent with a fight and being pulled away from each other. The defendant was ID'd through TCIC and driver's license.
Did you say that she was the initial aggressor?
Your Honor, I'm not sure the DIMS say who. Let me recheck that. Your Honor, all the DIMS say is the two began to fist fight. I can check to see if the defense report.
And then the other person hits her with a pole. Is that
I
what
think I think it was the other way. The defendant grabbed the metal paper towel holder and hit the victim. I'll see if the defense report and I'll see if we can see if that's.
Are you looking at this, Ms. Gilbert?
I'm looking at it right now.
Who's the initial aggressor?
Report.
Yeah.
It's unclear based on the DIMS. It just says they're hitting each other, which is why I'm looking at the OR right now. And
Yeah.
it
Go
sounds
for it.
very,
Yeah.
I understand.
Take a look. Sounds like the officer may not know either.
In the offense report, it says that Miss Marquez stated that she and Miss Ramirez were arguing, and then Miss Ramirez started to punch her, at which time she fought back.
Ms. Ramirez or Ms. Rivera?
The offense report says Ramirez in it. I think that's the confusion, Your Honor.
Okay. Ms. Rivera, I'm going to find that there's no probable cause to go forward with your case at this time. Please.
Now this is why body language in court matters. Judge Fleischer just looked at this case. Assault, metal paper towel dispenser to the head, 10 out of 10 pain, and he can't find probable cause. Because the officer's report is a mess. It doesn't say who the initial aggressor was. It's unclear. The names are confused. And you know what? Fleischer isn't going to rubber stamp a bad report. He's protecting this woman's rights by saying, I need clarity before I take away someone's liberty. That is due process in action. But watch his face. He's not happy about it.
Be very careful. We have enough blood on our streets as it is. We don't need any more. Do you understand? Okay, please take a seat.
Rodriguez? Right below that one, Jay.
Yeah. Good morning, Mr. Rodriguez. Sir, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On July 9th of 2026, an officer dispatched to 125 Weissenberger, number 18 in Harris County, Texas, in regard to a call for service. The officer met with the complaining witness and in Spanish got a statement. The complaining witness and defendant have been in a romantic relationship for 1.5 years. The complaining witness that the defendant becomes violent and physically assaults her every time he drinks alcohol. The defendant began a verbal altercation with the complaining witness, and then the defendant proceeded with punching her across her left side of her face with the defendant's closed right fist, and struck her an unknown number of times, causing her pain. The complainant stated that the defendant also punched her across her left arm with the defendant's closed right fist and struck her an unknown number of times, causing her pain and proceeding to pulling her hair and dragging her to the ground. The complainant stated that the defendant told her that he was going to kill her and throw her at the bridge located at the Memorial Herman Park. The defendant stated that this isn't true and nothing physical happened except the complaining witness pushing him. The officer observed the complainant to have a red small bump on her left upper face and red with 3 different bumps, about a ½ an inch, and redness to her left upper arm.
Mr. Rodriguez, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to give you a device that you're going to take with you everywhere you go and prove to me that you're not consuming alcohol. This is a portable breath test device you will take with you everywhere you go at all times. If you fail to blow in the device, I will revoke your bond and put you in jail, and I'm going to make your bond high. I don't know what your status is in this country, but if you're not in this country with permission and you go to jail and immigration finds you, it may not go very well for you, and you may sit in custody for damn near 9 months waiting on everybody to decide what to do. Do you understand? You are not to have any contact with this complaining witness, not to go where she lives, where she works, and on your other ankle, you will get a GPS monitor so I know where you are at all times. If you go within 1,000 feet of where she lives or where she works, then likewise into jail you go. Do you understand me? There is a protective order that has been issued in this case. You need to get to know it. If you violate that order, the state can and probably will file a violation of a protective order, and that is one of the worst misdemeanor cases that you can pick up. Do you have the ability to hire a lawyer?
If I'm working, you give me time, I can look for one.
We will give you time. I'm going to have you sign a reset. You will get with Mr. Michael for your bond conditions, and after that, you'll be on your way. Mr. Rodriguez, let me make something, and I won't want you to hear me loud, and I want you to hear me clear.
All right, sit back and appreciate this one. Judge Fleischer just told a defendant, I've made bonds $14 million before, and I'm not going to lose sleep if I have to do it to you. That's an all-time courtroom line. But here's the thing, this is not just tough talk. This is a judge who understands that bond is about community safety.
If you put your hands on anyone in a violent manner, I will put my hands all over your bond. And I have made bonds $14 million before, and I'm not going to lose sleep if I have to do it to you. Do you understand? I will protect my community at all costs. Go.
Gardner, page 18, Judge.
Good morning, Mr. Turner.
Good morning.
Sir, you're charged with 2 cases. You're charged with driving while intoxicated and unlawful carrying of a weapon. You were facing up to 6 months in jail on the DWI and or a $2,000 fine, and up to a year in jail and or a $4,000 fine on the gun case. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On July 12th of 2026 in Harris County, Texas, an officer checked in with the night shift unit on a traffic hazard call. When the officer arrived, the defendant was detained, but the officer present on the scene was transporting the different defendant to JPC when he noticed a motor vehicle stalled on a public roadway. The officer noticed the defendant asleep at the wheel. When the officer woke up, the defendant, he could smell a moderate odor of alcoholic beverage from the breath. The defendant said he did not drink, but there was a mostly empty bottle of Don Julio tequila and an AR-15 in the trunk. The SFSTs were completed, and they were a 6 out of 6 for the HGN, a 3 out of 8 for the Walkington, and a 0 out of 4 for the one leg stand. The DIC was red, and the blow was 0.115 on both tracks.
Where was he?
He was.
Was he in the middle of the moving lane of traffic?
No.
Stop. We don't need your help, man.
Stalled at the 2100 block of Deschardes Street, just after the exit ramp of US 59 freeway.
Okay. Mr. Turner, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. Does he have a license to drive?
His driver's license is eligible.
Any prior DWIs? You said there is alcohol in the car, right?
There was
like a half bottle.
I left out the window.
As a condition of your bond, I'm placing an additional restriction on you. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have one, I will revoke your bond and put you in jail. When I say illegal drugs, that includes marijuana and anything that has THC in it. If you use, I will just put you in jail. You understand that, Mr. Turner?
One thing I know is let's say the bond, the bottle was in the trunk.
So just don't, you have the right to remain silent. Nothing that you say now is going to change. These are just bond conditions that I'm placing on you at this time. As also as a condition, no weapons while you're on bond. You have the ability to hire a lawyer. I'm sorry?
Yes.
We will give you time. I'm going to have you sign a reset. I'll have you take a seat while we get the bond conditions ready. Once you sign them, at that point, you'll be free to go.
Great, Capo 19, Olas.
Veloz. You are Mr. Veloz.
Yes, sir.
Sir, you're charged with discharging a firearm in the metropolitan area. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On July 10th, 2026, an officer responded to a call for service at 2505 Crestline Street, Houston, which is in Harris County, Texas. This was at 7:02 in the morning. The officer noticed a visibly distraught witness who was the defendant's mother, and defendant who appeared intoxicated and hostile. The officer then noticed several 9mm expanded shell casings all around where the defendant was standing in his driveway. The officer then detained the defendant. The witness stated the defendant was firing the gun into the ground, and the witness gave permission for the defendant to enter the house, and the officer found a firearm. The witness stated the defendant had arrived home intoxicated and got into an argument with his wife, who left, and then witness stated that at that time, the defendant went into his room where she believes he grabbed his firearm and then went outside, and that is when she heard approximately 12 gunshots. This occurred in a metro area that was greater than 100,000 people.
So do we have a witness that sees him firing? Is that what you said? You said earlier that there was a witness, right?
Yeah, the witness is his mother. She heard the 12 gunshots. I'm gonna check to see if it says that she saw.
Mr. Veloz, I'm going to find that there is probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to test you to make sure that you're not using. If you do, I will revoke your bond and put you in jail. Do you understand?
Yes, sir.
You were also ordered not to be in possession of any weapons. Did they confiscate the weapon? Do you know? Veloz.
The officer found it and placed it in a marked patrol vehicle. They found it.
Right. Okay. If I find that you have any care, custody, control of any weapons, then likewise into jail you go. This is not a revolving door. You will not get PR bond after PR bond. If I have to put you in jail, I will make your bond high. Do you understand, Mr. Veloz? When I mean no illegal drugs, that includes marijuana. If you test positive, then it's just really not going to go well for you. We are going to reset your case to give you time to hire a lawyer. So I will have you sign a reset. You will meet with Michael for your bond condition eventually, and then we'll see you in a month. Come on.
William? Top of the line.
Good morning, Ms. Williams. Ma'am, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On June 28th, 2026, in Harris County, Texas, an officer dispatched to a hospital in regard to an assault. The officer made contact with the complaining witness, who stated the defendant was a friend of 2 months. The complaining witness said the defendant and her were arguing about a previous assault that occurred to the defendant by someone else when complaining witness decided to Uber home, and the defendant told her to leave immediately, not to wait outside.
Well, okay, hold on. She was Ubering home or the other one was Ubering home?
Complaining witness was Ubering home.
Okay.
The defendant wanted her to leave at that point. Defendant, and it was having a wait outside. Defendant then exited the residence and intentionally struck her on the back of the head approximately 15 to 20 times with her fists, causing pain and bodily injury. The defendant said the defendant then attempted to grab her hair and slam her head into the concrete, but was unsuccessful after the complainant's wig became detached. This was until another individual stopped the assault. The officer observed injuries consistent with the account, and the defendant was identified by Texas Sheriff's Office.
Ms. Williams, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to have any contact with this complaining witness and not to be in possession of any weapons. If you have any contact with this person, and I don't care what the excuse is, I will revoke your bond and put you in jail. You got a PR bond. We gave you a free one. This isn't one where you're going to get free after free after free. Do you understand? I'm going to protect my community. You endanger it. It's just not going to go well for you. There's nothing that you can say at this time that's going to change anything. We will, at some point, you'll get a lawyer. They need to get the evidence. The evidence is going to point to whose side is correct. I don't know. I wasn't there. Right now, I'm putting conditions, number one, to ensure public safety. Ensure that you don't pick up any cases, new ones. Otherwise, really, you understand?
Yes.
All right. Do you have the ability to hire a lawyer?
I'm not sure, but just in case they have a.
How do you support yourself?
I clean houses for a living. I clean houses for a living.
Okay. And who do you live with?
I actually stay with my brother.
Okay. Deputy Chigon will give you an application. I need to know everything about you, how much money you make a month, other household income, and then I'll take a look to see whether you qualify. If you put just zeros on it, I'm going to send it right back to you because it's just not true. I need to know how.
My own first. Should I try to hide my own first?
Well, that's up to you. I can't make that decision.
I just might just find hearing of those things.
I'm happy to give it to you. If you go out and you have problems, come back and we can talk. But understand, don't pick up any new cases. Don't have contact with this person. I don't care if this person reaches out to you.
I don't know the name of the person.
We'll give you bond conditions and then they'll have the name on it. Okay? All right. Please. Do not leave until you sign the bond conditions as well. Okay? Please. Yeah, we'll have you sign a reset and then we'll have you take a seat in the jury box.
Did you want to follow one?
Please, no contact, no weapons, and no going back to where this person lives.
There was like a distance, like, right? There wasn't a distance.
No, just don't go back.
Thank you.
That's it for now, Judge.
Got it.
Covered?
Okay, Mr. Henry, you ready?
Morning, Judge.
Hey, good morning. What's up?
Last name Miles from document. There's a New York.
Mr. Miles, come up. What say you, Mr. Henry?
I would like for him to explain the issue that he's been having with the device, because when I'm looking at it, it's not making any sense. There have been, this is like, obviously this is his first one, but
It's not his first one. He had a bond violation in June.
I didn't see that. I just checked with the pre-trial. I was just informed it was his first one, because I was looking for that
It's
first.
his second
What
one.
was the first one for? Because I don't have that one in my email. Because it's listed, I have the email as.
He was supposed to do AA meetings and he hasn't done it. And the pretrial has tried to get a hold of him and it's been unable to.
I'm not sure about that one, Judge.
I'm telling you.
Okay, yeah. I was unaware of that one, Judge. I'm looking for it, but specifically with this one, he's been having issues with his car and with the interlock device. I informed him that he might be going into custody today, but before that, is there any way we can possibly do a scram device instead, just to give him a chance?
It's 220 days old. We set cases for trial at 180 days. I gave you a pass the first time. You don't get multiple ones, man. Otherwise, I become the enabler. Do you understand? All right, it goes with you. You're going to jail today. I'm sorry, but I don't know, it's 213 days. Are you just now, or how long have you been on the case? Okay.
Just, I'm barely.
Got it. Okay. Yeah. Take your time. Don't take your time. It's 213 days, but we'll give you an additional couple of weeks. But at that point, you guys got to come back and let us know what you want to do. You're going into custody now. I don't know if that's, you guys talked, but
I'm gonna get a bond from.
you're going to jail today, sir. Okay. Thank you, Mr. Henry.
You know what the bottom amount is in the bottom amount?
5,002.
5,000? All right. Thank you, Judge.
Okay. Victoria, who's this?
This is Henderson
Henderson.
on page 7.
All right. Good morning, Mr. Henderson. Sir, you're charged with possession or use of a criminal instrument. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On July 9th of 2026 at approximately 3 a.m. in the morning, officer observed a Chevrolet Tahoe back into a dark parking space behind the Strip Center at 19801 block of Gulf Freeway, Webster and Harris County, Texas. The officer knew the vehicle to be a suspect vehicle associated with several recent copper thefts being investigated. Officer conducted a traffic stop after IDing the defendants and defendant's passenger, Jennifer Quinn. Officer knew both to be primary suspects in the same copper theft investigation. The defendant stated he had parked behind the strip to work on his vehicle. The other officers located a freshly cut section of fencing adjacent to where the Tahoe was previously observed to be parked. The officer requested and received consent from the defendant to search the Tahoe, where officer recovered bolt cutters, fence cutters, a handsaw, pliers, double insulated gloves that appeared to be sweaty from recent use, binoculars, loose wire, and copper. Based on the officer's training, these items are commonly used in the commission of copper theft offenses. After Miranda of both defendant and Quint, defendant invoked his right to counsel, but Quint voluntarily agreed to speak to officers in hopes of charging consideration. Quint admitted to acting as a lookout for defendant at 4 copper thefts under investigation and independently ID'd photos of victim locations shown to her by officers.
What time of day or night was this?
This was at 3 o'clock in the morning.
Mr. Henderson, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. I'm going to test you like crazy to make sure you're not using, Mr. Henderson. And if I find that you do, and I don't give a rat's behind what it is, you will go to jail. I see this and I see what you're on bond. I have no problems making your bond upwards of 6 zeros, 7 zeros if need to, for me to protect my community. Do you understand? You will get a GPS monitor, and I'm now giving you a curfew of 7 p.m. to 7 a.m. You are not allowed to go out at night. You go out at night, and I don't care if it's to have a smoke, you will go into custody. Do you understand? Test next week, please, randomly. We are going to reset your case to give you time to hire a lawyer. Mr. Henderson, there are no mistakes in this life. There are choices. You either make a good choice or you make a bad choice. And here we are in just a very short time. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, and now open 12 and 13. Do you understand me?
Yes.
That's it, Judge.
Okay. Hey, Shatoria,
Yes.
are you ready? Is Palomino, is that ready for dismissal? Is that Joel?
Good
Oh,
morning, Judge.
sorry, it's not with you. Palomino, it looks like it's a PTI. I don't know. Who did you send? Did you send the documents today?
No, so he's going to do the community service this weekend. He already has the driving course completed.
Oh, this is the guy that we've been rolling day for day?
Yes, Judge.
Did he get
He'll
it
be
done?
done. He'll be done pretty soon.
Okay, all right. So we'll put him on for Monday.
Could we do Tuesday, Your Honor?
Nope. Hey, Palomino, Monday. He's had plenty of time. I'm not going to continue to just do the same thing over and over, man. It's not you, Joel. It's your client.
Do I have to check in on Monday?
Yep. And he will. I mean,
Judge, if I'm at another court, how do I mean,
well, have him give the documents to you, and then you guys can, whenever he gives it to you, you can email it to the state, and then they'll dismiss it. But
Okay.
it's got to be here Monday.
Okay.
I
Thank
had
you, Your
2
Honor.
months to get this done. I'm not going to continue to perpetuate it.
Okay.
Okay?
Okay.
All right, man.
May I be excused?
Yes, sir. Thanks.
Okay. Have a good one.
Bye.
Good morning,
Ready?
Your Honor. May I approach?
Yep. Ms. Abernathy, you're next. Okay.
I'm encroaching for Mr. Long, who you called on about today.
Okay. Come up, Mr. Long. So he had a bond violation in June. He has a bond violation 7/14/26, and they filed, I guess, another bond violation report.
Yes, sir.
Balls in your court.
Yes, sir. So on 6/29, Mr. Long and his family experienced a medical emergency, which the court has been aware that he was at the hospital. And if it pleases the court, either Mr.
The court is aware?
It was in the email that was sent. Yes, sir.
Is it, did you,
It's on the email that was sent on 7/14. It says additional on 6/29, client's GPS indicates travel to the hospital. Client does not provide documentation of the emergency. No calls were made after hours in that situation. If it pleases the court, either Mr. Long or his mother, Ms. Long, will be able to explain that.
I can't even pull it up. I'm having trouble pulling it up.
Yes,
Just the email won't work. I don't know what the hell's wrong with this thing.
it's gonna be for the second violation. It'll be in that email for the second violation. Would it be easier, Your Honor, if I show you the email via my?
Yeah.
Okay. May I approach?
Please. See if that works. So you're showing this right here? This?
Oh, scroll all the way up. I'm sorry. And it says where it says additional. There's a small paragraph, 2 lines.
Okay, I need more than just
Yes, sir.
to the hospital. I mean, I need hospital records from him detailing that he was the one going to the
He
hospital.
was with his mother and brother and that information.
But he doesn't have to go to the hospital. If it's not on him, he doesn't have to go.
Yes, Your Honor, if I may, his mother come up, I feel like it would be insensitive if I explain what happened, and I would prefer if his mother or he could explain what was going on with his family at the time.
Sure.
Ms. Long,
Hey, can you pull up the GPS records for Mr. Long? And I'd like to know, because they're saying that he went to the hospital. Did he actually go to the hospital? How long was he there? Hi, your mom?
Good morning.
Good morning.
Hi. Yeah, we had an incident with my oldest son. He had got robbed and he was shot 7 times. So he did run to the house for us. We waited for the ambulance, but they were taking too long. So we rushed out and Nico did with us as well. So we transported him to the hospital. I do have hospital records stating that we were there at the hospital on the 29th. The next offense, he had to go because he's at HCC. I'm loud. He goes to HCC and our computer isn't working. So he was at one of his friend's house to log in for class. I work for Metro, so I was late picking him up on the 2 instances.
But I understand bond conditions are bond conditions, and you can't continue to violate bond conditions without some kind of consequence. This is now a 3rd bond violation. And it seems like there's always an excuse here. It's always an excuse there. It's always a couple minutes here. It's always a couple minutes there.
Whoa, did he just say what I think he said? I hope to God you don't have children. Judge Fleischer just went full dad mode on a 17-year-old's mother. But honestly, look at the context. 3 bond violations in 3 months. He's got the GPS records. He's watching this kid go out at 1 a.m. and he's thinking, this is how people get hurt. The judge isn't just being mean, he's frustrated because he's trying to save this kid from himself. And here's the legal reality. Repeated bond violations aren't just minor infractions.
He's not the one that needs to go to the hospital. He's on bond for a criminal case, and we've ordered him to stay at home. Nothing good happens for, 17?
Yes, Your Honor.
At 1 a.m, 2 a.m, 12 at night for a 17-year-old out there. And I'm trying to keep him home so that he doesn't get in trouble. And it's like, you don't have any children, do you? I hope to God you don't have your 17. Children, what they do is they push and they push and they push to see what they can get away with. And they do it over and they do it over. Some defendants here act like children as well. They try to push and they try to push to see what they can get away with. It's maybe 2 minutes here, it may be 3 minutes there, but the fact remains is that it continues to happen. And if I don't take action on it, you've now in 3 months have 3 bond violations. If I let you go, what's going to happen next month, Mr. Long? In 3 months, you have 3 bond violations. And it may seem minute to you, but a bond violation is a bond violation. You don't get to violate and then ask for forgiveness after the fact. Do you understand? So, Mr. Michael, tell me about his.
Just have the case mentioned now, look into it. She is,
Okay, I'd like to know exactly, I'm not going to take anyone's word for anything. I'd like to know, especially on the one that he's out at 1 a.m. I want to see where he's going, if there are any additional stops, if he's going anywhere else. Is he truly at the hospital? How long? But all I know is that it's just, we're now on number 3. I don't know. I mean, I'm not going to make any promises. I'd like to see what the actual monitor says, where he's going, how long he's out. And so I need some time, ma'am. So I'm going to have you take a seat while we pull the GPS records to see where he's going. But nevertheless, though, he's not allowed to go out.
Yeah, we did try calling pretrial services when that happened. And we wasn't thinking, Your Honor, we just rushed out. We didn't know if my son was gonna make it or not. Once we arrived at the hospital, we did try calling pretrial services so I could make them aware of the situation.
I understand,
Yes.
right? But I still, after that, have another bond violation after that. And then I have another bond violation before that.
Yes.
So, even if I give you the benefit of the doubt on that one, I still have one after and I have one before.
And Your Honor, if I may be heard, on the violation for the 30th and the 14th, as Ms. Long stated, she's a single mother and she works for Metro, and Nico actually reached out to ask did he need to get an Uber or a rideshare to get home, and she told him no because she believed that she would make it in time to get him. So while we do understand and we respect the court's conditions and the curfew times, he was making attempts to get home. His mother did, as a single mother, she's the only one who has a vehicle. He is 17 years old.
He could have made plans beforehand. If you know that you have to be home at 9 o'clock, you don't stay at someone's house at 8:50 and they go, oh, damn it, I need to get home. What the hell am I going to do?
Your Honor, that was not the case here. He made arrangements with his mother. He asked, like, do I need to call Uber? And she said no. She denied, well, she didn't deny, but she told him not to, so that because
then you are setting your son up for failure is what's going on. It's over and it's over and it's over. But regardless, we're beating a dead horse. I need to know what those records truly show for now. So just take a seat, ma'am. Let's get it and then we'll go from there.
May we be excused at this time?
Please.
Thank you.
All right. Herman,
Sir,
hey,
don't shoot the messenger, but I'm trying to avoid a PBR.
it seems like we're here every other day.
Yes,
Okay, what's now?
26, 17, 11, 12.
Wait, what?
He is leaving tomorrow. A different client is leaving tomorrow to Florida to the 22nd. He is a low VAC. In fact, one of the samples came back under the legal limits, extracting music, and it's no accident as well. He's staying in the country this time. It's a different person. He's staying in the
Okay,
country.
so we'll give him a portable device and he'll have to take
He
the
has
portable
he has
device.
a portable now.
Oh, if he has a portable device, then we're good to go because it'll test wherever he goes. Just make sure that it tests that while he's in Florida so they can,
Okay.
when they get back, they can see, but
I'll confirm he has a portable.
I don't know how the time change will affect it, but it's,
Yes.
if you are going on a trip and you come here,
On the ride,
that's,
yeah, the day before.
it seems to just continue to happen. I don't know.
Yes, I understand.
Yeah. Okay. If he's got a portable device and it's operational, he'll get drug tested when he gets back.
Okay.
I mean, My only concern is that he's not drinking. If we've got a portable device that'll work down there, I'm happy,
Sure.
then everybody's happy.
I'll ask you.
A few minutes later.
Okay, all right.
And then for Mr. Controller, I'll talk to you about the adding portable device.
On who?
Mr. Controller.
He told me that he already had a portable device. I'm denying the travel. I mean, he lied to me. He told me that he did have it. No, no travel. Hi,
How are you, sir?
what's up?
Oscar Dalton. Right here.
Dalton?
Dalton.
Come on up, Dalton. Happy Friday. Good to see you, man.
I'm wearing all this crazy color. You're wearing, I like that suit.
Wait, but it has Beetle, not you.
Huh?
It has your other half.
Yeah, I know. It's with the yin and the yang. It's a bold jacket.
How's everyone? Good?
Everybody's doing well. They're just running a million miles an hour. It's-
When you're a rock star,
Yeah, right. It's a good problem.
that's right. Mr. Dalton, good morning, sir. Sir, you're charged with driving while intoxicated and reckless driving. On the DWI, you're facing up to 6 months in jail and or a $2,000 fine. And on the reckless driving, up to 30 days in jail and or a $200 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
We raise public cause.
I'd like to know the reckless driving and the DWI are really concerning.
On
Please.
July 11th of 2026, at approximately 4:22 in the morning, an officer was dispatched to an aggressive driver call near 1800 block of South San Houston Tollway in West and Harris County, Texas. The complaining witness advised the aggressive driver in a blue BMW had tried to run the complaining witness off the road and was actively following behind them. While responding, the officer observed the speeding vehicle nearly collide with them. That nearly collided with then for around a semi-truck without simulating a lane change. The officer paced the vehicle at 120 miles per hour in a 65 mile per hour zone.
Running people off the road allegedly as well?
The officer identified the vehicle as a black BMW, which closely resembled the complaining witness's description. The officer conducted a traffic stop and detained the defendant for reckless driving. Officer noticed a strong odor of alcohol emanating from the defendant and observed glossy bloodshot, watery eyes. The defendant denied alcohol consumption. The defendant refused SFSTs and a breath skin. The officer conducted a blood warrant drawn at 6:30 in the morning.
So you said he's bloodshot eyes. Did you say odor of alcohol? What all
Strong
did
odor of alcohol emanating from the defendant and glossy bloodshot, watery eyes.
you? Okay. Mr. Dalton, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using alcohol or illegal drugs, I will revoke your bond and put you in jail. I don't care who the hell you have next to you. You endanger my community. It's just not going to go well for you. Because of all this, I'm now requiring you to obtain an ignition interlock for your car. You are not allowed to drive any vehicle that doesn't have an interlock. You violate this condition, then likewise, I will revoke your bond and put you in jail. This is not a revolving door. If I have to put you in jail, just, you understand me? I have no problems making your bond as high as can be, really. Just because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with counsel. If he tells me he cannot get a hold of you, then likewise, I will revoke your bond. For now, we'll have you sign a reset. We'll get you with all the paperwork and then you're free to go.
Thank you. Have a big season.
Good to see you, man.
You too, Judge.
I can't get anything to work again. This damn computer. Okay, Miss, give me 1 second. Okay, tell me about Mr. Evans, Miss Abernathy.
So my understanding is that he had 2 probation violation warrants out of Jefferson County. Jefferson County was aware of the Harris County case and knew we were going to do a PTI. Our understanding was Jefferson was supposed to dismiss their warrants, and I'm not 100%. This was what I remember.
Is Mr. Evans here?
I don't know.
He's not here. I'm revoking his bond.
Yes, sir. I understand.
Yeah, he's not here. Okay.
Okay.
All right. I guess we'll just let us know when you hear from him, you know?
Yes, sir.
So he did pick up another case in another county? Is that what you said?
No, No, sir. He had been on probation in Jefferson County, picked up the DWI here in Harris, and then they were aware of the Harris County case and were okay with him doing a PTI and said they were going to dismiss the MAJs and I think amend his conditions to include some of the PTI conditions.
What was he on bond for? What was he on probation over there? DWI?
Judge, including engaging in organized
I
criminal.
believe it was.
But he was removed from our DWI program because he continued to fail to show up or respond to any messages.
Got it. Okay. All right. I'll end up revoking the bond today. And then just let us know when you hear from him.
Yes, sir. May I be excused?
Yes, ma'am. Thanks.
All right.
Okay,
Y'all
ready?
have a great day. Thank you.
Yeah. I'll hit you up next after this, Victor.
Can I get Mr. Malone?
Yes. Ms. Fallon, come up.
Where you go?
It may not be today. It may not be tomorrow, but one day you will eventually regret this. You had the opportunity to get this thing dismissed, and now because of the decisions and the choices that you made, you now will end up with a conviction on your record, and it will be there for the rest of your life. And I'm going to tell you, every time you get pulled over, officers want to know who they're dealing with. So the first thing they're going to do is they're going to look to see, who am I dealing with? They're going to see that you have a DWI conviction. If they roll up to your car, they smell alcohol, they smell anything funky, it may not go very well for you. And what we're doing today, it's now a minimum of 30 days in jail. Do you understand? You were giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. You understand? If you're on probation or parole, this can be used to revoke that, resulting in further confinement. How do you plead to this offense? Guilty or not guilty? I'm going to find you guilty. I'll follow the agreement, send you to it. I am going to suspend your license for 180 days. Do not drive until you get a license. Good luck to you, man. Thanks, guys. We'll have you see the clerk. Okay, Victor.
Good morning, Judge. How are you?
Hey, good morning.
Judge, I've got Julian Borrego on your docket this morning. It's a BVR. It's his first BVR.
Let's see. Borrego, come up.
Thank you. Judge, I'm not sure if you have the BVR.
I got it. I see it.
Okay.
I'm going to put a scram on it, Victor.
Say that again, Judge?
I'm going to put a scram on him now.
Okay, I understand, Judge. Just so I can explain a little bit, Judge. If you look at the timestamps on the violations, one of them's at 7:54 in the morning. It's apparently a .033. The next one is 10 minutes later. It's a .035. So it would indicate that he would be rising. But 10 minutes later, then he clears it completely. It's a .028. And so
you're supposed to be a .00.
No, I understand, Judge. I'm just saying, if he were, for example, on a PTI or something, the device or the contract tells you to blow 3 times to clear it out, which he followed those kind of rules. That I'll let you explain to him what you want to do.
I'm now amending your bond conditions to put a scram ankle on your monitor. After this, I have nothing left at my disposal but jail. You are on absolute no tolerance now. I don't give a rat's behind if you're using mouthwash. You are told exactly what you can and can't do with the devices that you have. From now on, anything that goes, you will go in. Do you understand me?
Yes, sir.
This case is 170 days old. What are we doing with this case?
We're getting together a PTI package, Judge. We're supposed to be in court next week on the 23rd. And so if Your Honor gives us a couple more weeks.
I'm not giving you a couple more weeks. It's 170 days old. I'll give you a week. If you want to enter into the PTI program, it is your responsibility by the next setting to get all the documents to your lawyer so he can submit them for the PTI program. If you don't have it, then at the next setting, you must either accept a plea bargain agreement or I will set your case for trial. It's entirely way too much drama. And when we do, it's time to, you understand me?
Yes, sir.
You have 1 week. All right, we'll have you sign a reset. Pick any day you want next week, Victor, and then I'll have him come back. He's got to get it to you.
Can we keep him on the 23rd then, Judge?
Sure.
Okay. Thank you, Judge.
Okay.
May I be excused?
You got it, Victor.
Have a good weekend, Judge.
Michael. This is Mr. Borrego on the bottom of page 3. Today, please. Thanks.
Thank you, Judge.
Thanks, buddy. We'll see you then. Hey, are you ready?
Yeah, sure.
Coming up. Yeah, let's pop.
Mr. Morales. He's in the jury box on a file violation, Your Honor.
All right, bear with me. Let me just sign this real quick. All right, can you bring Mr. Morales up?
Mr. Morales.
Did you just get appointed to these cases?
No, Your
Are you here for
Honor.
Stephanie?
I'm here for Stephanie. She said she got an email this morning about the violation.
You can get up.
She was not in town. If I could approach it.
Yeah. I have a real problem with Mr. Morales. Mr. Morales, did you hear everything that I told the other gentleman that was up here right before you? Did you hear everything I told the other gentleman? The exact same thing applies to you. It doesn't matter what we say. It doesn't matter what we do. Some children tend to push and they tend to push and they tend to push to see what they can get away with over and over and over. Here we are on your third case, and I've told you to stay at home over and over. The reason is because I don't want you to pick up another case. I'm doing everything in my power, and yet you persist to have bond violation after bond violation. And this is now your probably 5th bond violation. I don't care that you're out 3 minutes past when you should be. The fact is, it's yet another violation. Over and over and over. Don't be playing Helen Keller. You know exactly what's going on, man.
Your Honor, I briefly spoke to him about the situation, but you know, behind him.
He got left. It came back at 9:44.
And he said that, I don't know, previously, I haven't looked at the previous bond condition, but his curfew was from 10 p.m. until 6 a.m.
It's 9 p.m. to 6
And
a.m.
that's what I told him. He did say that once they called him that second time, that he realized there was 96. He did explain to them that he believed it was 10 p.m. to 6 a.m. Ever since that
Sure.
day,
I told him what it was.
I understand.
Guess what happens now, Mr. Morales? Guess what happens now?
They told me on Monday when I was.
You signed paperwork. And I told you. And I know that I'm not speaking in a different language, man. Over and over. Push and push. Now I'm going to double all your bonds. Goes with you.
Thank you, Your Honor. Do I reset him or?
He'll auto-populate on Monday's docket. I don't know if he's going to bond out, but we'll go from there.
Perfect. Thank you, my agent.
You got it. Thank you so much for coming. 25,003 on the DWI, on the assault, and then 1,000 on the police. Are you ready, Mr. Francis?
Yes, sir.
Talk to me.
Hey, Judge, check out Brianna Treadwell.
Okay.
Yeah, she's MRP, DWI MRP, and then she picked up the new theft. So question becomes, did you want to reset that for an MRP, or did you want to carry the theft case with the DWI MRP?
So she's supposed to get off this probation September 26th. You know, she was the one who went into residential, so the only remaining condition she has is the DWI repeat offender scores and an effective decision making class. But she's been inpatient treatment, she's done IOP and SOP, she's been reported to her probation officer. She just picked up this.
She's doing well.
And she's been struggling economically. She's trying to find a job, and I think things are tough for her and her kid in her big day.
Let's carry it to maybe middle of next week.
Yes.
And then I'll consider. Okay. And then we'll carry it.
All right.
All right.
Fantastic.
I set the bond at 10,003 on the probation case. I set the other one, or I left the other one as is.
500.
In the event that she doesn't, let's talk next week
Okay,
and we'll go from there.
I'll make a note.
Yeah. Okay.
Awesome. Thank you, Judge.
For sure. And then we'll carry it. You think, should we do a new TRS? Circumstances. Hey, watch your head, man. Have circumstances changed?
I don't, she's not tested positive and she's been compliant to her. Yeah, her last year, I can do anything except it was I don't think it's outlawed. I don't think this might be.
Yeah.
But I'll do it too.
But I guess it's going to auto-populate on Monday regardless. So it'll auto-populate Monday. We'll come back and talk then.
We'll revisit.
Yeah.
Okay.
Yeah.
Fantastic.
Okay.
Williams?
Yes, please.
Good morning.
Hi.
I have a walkthrough and then 2 off documents. I'm covering for something.
Chapman, come on up, sir.
Ramirez?
Did you get the cause number for this?
No.
You ready? Or you want to give it to me? Sure. All right. Good morning, Mr. Chapman. Sir, you're charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you can afford one, one will be appointed to you.
On June 21st of 2026, an officer was assigned an assault bodily injury case for further investigation that occurred at a bar lounge area in Harris County, Texas. The incident is documented upon reviewing the narrative. The officer who was working at a front desk in the APD Southwest Police Station located at 13097 NITID Street. And when Mr. Royce Ballard, who is referred to as complainant, walked in to file a police report regarding an assault incident. It was discovered that the assault had originally occurred at the approximate location of 3917 Richmond Avenue, another location in Harris County, Texas, and the assault occurred on or about June 21st of 2026. The complainant stated that he was assaulted by his current girlfriend's ex-boyfriend, who he knows by the name Derek Chapman. The complainant stated that he and the girlfriend were leaving the establishment of the bar lounge, and defendant and him had an exchange of words. However, the defendant, Ballard never threatened that Chapman, but Chapman threatened to hit Ballard. The complaining witness stated that the defendant then punched him multiple times in the face. The complainant, Ballard, said that he did not want to engage and remove himself from the situation by exiting the establishment. The CW said that they exchanged a few more words. However, he never struck or threatened the defendant at any point. The CW stated that defendant then left the scene in what he believed was an Uber, and complainant stated that he felt pain when defendant Chapman punched him in the face using closed fists multiple times. Complainant stated that he is still sore from the assault even 24 hours later.
So do you think that alcohol played a part in this? Is that what you were saying?
It occurred at a bar lounge area, so I don't have information in the days about it. If they're at a bar.
Okay.
There's a little bit more here. I just want to keep reading.
Go for it. Yeah, go for it. No problem.
On June 30th, the CW, the officer again established communication with the CW, the complainant, and he confirmed his original statement. The complainant further stated that he had never met the defendant in person prior to the incident, and that he only knew of him through his current girlfriend. He further specified that the threats were up to the effect of, "Man, I will knock you out." But he initially did not believe that they would follow through with the threat, the defendant would follow through with threats, and that the defendant had struck him approximately 3 times with a closed fist in his face and neck area. And he experienced pain and soreness, as we have previously stated. He also states it was captured on the surveillance cameras. And then the defendant was ID through TC, IC, NCIC.
Got it. Okay, Mr. Chapman, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If I find that you're consuming, I will revoke your bond, put you in jail. There will be no more PR bonds for you. Do you understand? Also, as a condition, you're not to have any contact with this complaining witness and not to be in possession of any weapons and not to go where they live or where they work. I will protect my community at all costs, Mr. Chapman. If you violate this, you are a danger to it. It's just not going to go well for you. Do you understand? Okay. You guys talk about a bond?
We did it. But I am requesting a PR bond.
Okay. State what's your position on a PR bond.
I would have to ask them. I don't, can I say that?
Yeah, of course.
I would say no, it's an assault and that's not good. Let me check his criminal history.
That's a great idea. Good job. But that's one of the things that you would do when you're looking to see whether someone should get a PR bond. But in all seriousness, you want to see, are they a danger to the community? Have they had a PR bond before? Are they on bond for something now? Is it something that they can get a PR bond for? There are certain cases you can. In certain family violence cases, there's just no PR bonds, like a terroristic threat. So take a look.
It's looking like there's no criminal history. Yeah, so it looks like there's no criminal history and this was the first time.
Okay.
So, yeah.
What do you think?
May I give a little bit
If it was just his first case and it occurred at a bar, maybe it's fine.
You're a gentleman and a scholar. I will grant you a PR bond, Mr. Chapman, but this is not a revolving door. If you're a danger, like I said, I will revoke this bond and I'm not going to give you another one. I will set your bond today at $100. I will grant you a PR bond. But I'm not asking for much, man. If you look at the news, it's devastating how Houston is just ravaged by this and by that and the blood and the killing. It's disgusting. Just be careful. Don't do anything. You know what I mean? All right. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with them. If they tell me they cannot get a hold of you, then I will revoke the bond. All right, so for now, we'll have you sign a reset. You'll meet with Mr. Michael for all your conditions for your PR bond, and then after that, you'll be free to go. Okay? Oh, no weapons as well, please. Well, nobody, just part of the bond conditions. Okay. Please.
And Your Honor, I would like to approach on two off-docket matters on behalf of the
Okay.
attorney. The first one is their vibes. The cause number is 260-9695.
Okay.
We are requesting to amend the bond conditions. She is currently restricted to remain in Harris County surrounding counties.
This is Ms. Vibes?
Yes.
Okay.
And we're requesting that because she received a new job that will require her to travel to Minnesota every 2 weeks for her new job.
Is she under bond condition to test? Do you know, is she ordered not to use alcohol or drugs?
I don't have that information.
No, I don't see it.
It looks like it's just not contact. No weapons.
Actually, it does here in the original conditions. Yeah, I'm cool with it. Yeah, just make sure that she stays in contact with you so that guys don't lose each other, you know? What else you got?
And then I have Kobe Simon, cause number 260-7615.
Hold on. 260.
Oh, sorry.
That's okay.
7615.
7615. Okay.
So this morning he received a text for RUA and he's currently on a boat for work and he can't report. But he's in the middle of getting us his updated and pretrial services, his updated schedule.
That's a problem. You can't just up and go and not be ready so file the BVR. I mean, if he doesn't show like he's supposed to and didn't put anyone on notice, that's a no-go. File the BVR. As soon as we get it, then I'm going to order him to appear And I guess we'll go from there. It's just like how we address everything, but you can't just up and go, not let anyone know, especially if you're on bond for DWI and if you're subject to random testing, just. So they'll file a BVR and then we'll probably put it on docket for sometime next week. Do what you can between now and then. You know, typically when we have this situation, they let us know beforehand. You just don't up and go and then we do some other, whether we order like a scram so they can take it with them or a portable device, they can take it with them so that we can know that they're not drinking. Now we just don't know and we can't test them. That sucks.
Okay.
So file the BVR and then we'll go from there.
Thank you.
Mr. Johnson, did you bring your client?
Yes, sir. Mr. Lasco.
Come up, Mr. Lasco. So, hey, he's not on, you didn't have him on, Mr. Johnson, he's not on docket today, right?
No, you're not.
Okay.
Well, he did, matter of fact, she added him yesterday. Victoria added him yesterday.
No, he's not on the docket, Judge.
Oh.
So let's do this. I need you to give them the cause number. We already have the orders. They'll put it in and then I'll sign it.
Perfect.
So, Mr. Lasco, I'm amending your bond conditions not to have any threatening or harassing contact with the complaining witness in this case. What is threatening or harassing doesn't matter what you think is threatening or harassing. It's what the person perceives. I could care less what you think. So if you go like just to this person, that can be conceived as threatening and harassing and it can land you in custody. I don't know what kind of relationship you have with this person, but if it's something that you're constantly butting heads, you need to be very careful because if they call up here and they start saying, well, he's threatening me. You understand? Okay, man. We'll have you sign conditions promising us you'll not be threatening or harassing and no weapons. And after that, you guys are free to go. Okay?
Are we approaching that, Mr. Law?
I have a problem.
I'm sorry?
I have a problem with this. Shh. And the problem lies in the fact that we tell you, go home, stay home. You are not allowed to leave. If you have a problem, if there's an emergency, I mean, I get it. It happens sometimes, but you can't just up and go and then go to a convenience store for 10 minutes and hang out for 10 minutes and then go back to the hospital. And here, he's going out in the middle of the night, which is exactly what we don't want to happen. Come up, Mom.
All right, man.
I know that you may not think that this is a big deal,
I do.
but it is.
Yes.
You know, he's out. The exact thing that I'm trying to prevent is him going out in the middle of the night. And he is out at 1:30 in the morning, hanging out at a gas station. That's not cool. It doesn't, there's no excuse that you can give to justify going to a gas station and hanging out for 10 minutes.
We went there, Your Honor, because they put the hospital on lockdown. So homicide detectives, since I had to go to the bathroom, they said we could go to the store on Hofmeister. Because they had the whole hospital on lockdown.
This is why we have bond conditions.
Yes, I understand.
But
I totally understand. And I appreciate you putting fire under Nico's butt to get enrolled in college and also seek a job. Like I said, that incident happened, we wasn't thinking, because my son nearly died. So initially, we just all got in the car and took him to the hospital. I get it. I totally understand because I am the same way with being strict on me.
I don't know what to do. I truly don't. You know, on the one hand, I don't want to put him in jail, but we're here on number 3 and he's hanging out at a gas station. How the heck do I know what you're saying is applying and you're just not covering for him? How do I know? But I know you're saying that, but how do I not know that? We work in a courthouse.
Yes.
We work with evidence. We work with proof. We don't work on gospel, spoken word, promises, faith, this. No, we work on proof. And the only thing I asked was to get your butt and stay home. And yet we're on number 3 and he's hanging out at a gas station at 1:30 to 2 in the morning.
Did they see when they tracked him at the gas station that we went back to HCA on Huffmeister?
Yes,
Yes.
right.
That's only because homicide detectives, when they put the hospital on lockdown, we had to go to the bathroom, so they advised us to go to the gas station that was close to the hospital.
And if they invite you to go to a nightclub just to go hang out there while everything till it dies down?
No. But they had the hospital on lockdown, so once we went to the gas station, we went back to the hospital until homicide lifted the lift off the hospital. To access, for us to have access to get in the hospital.
I'm at a loss. Because on one hand, I understand that you're his mother, but here we are on bond violation number 3. And I just don't think that you can control him. And I don't know if this is a proper environment for him to be in. Because here we are on bond violation number 3. And if I let you go, what's going to happen? Right? I mean, history dictates what's going to happen in this case if I let him go. I don't know. I don't know what to do.
Your Honor, at this time, we just ask that you admonish him and give him another chance, give grace.
I've done that twice before.
Yes, Your Honor.
And here we are again. Am I either speaking Mandarin or am I just, my words have no effect? Because invariably, there's just going to be another excuse. There always is. We're on number 3. Hey, I can't sign the vote conditions. Doesn't let me check it out or get out to sign it. I don't know. Just take a seat for now. Let me talk to them. I don't know what I'm going to do. I just don't know.
Yes, Your Honor. May we excuse?
Yeah, please. I haven't even asked your position state, I haven't even asked you to see what your position is either. So just, I guess, think about it for a little bit. Let me get them out of the way and then I'll ready to.
Your Honor.
Hi, Ms. Henley. You ready?
Judge, I'm going to put you on a spot on the about the bond condition.
Okay, tell me.
We just need to get clear because she is in that complex where this occurred. And she's on housing.
I'm okay. I'm not telling her not to go back to the house, but I don't want her to go to the leasing office.
So can she still call the lease? I mean, you know how things happen.
No. Well, the problem is what happens if the complaining witness answers the phone? How are you not going to know? She's going to have to use someone else, but I'm not going to take her word that she's going to be good and not have any issues. I mean, I just don't want any further action. There's already what appears to be bad blood. Come up, Ms. Bohanna. Is she here?
Yes, sir. She sat out there because I was talking to her. She's 67 years old.
Ms. Bohanna, I understand that you live at the place. We put conditions on for a reason, not to be onerous, not to be obtuse or mean, but we do things for a reason. I don't want you to pick up any new cases. I don't want there to be any bad blood. I don't want you to accidentally run into this person and then you guys start just the best way is to keep everybody separated. The reason that we do what we do is so that nothing accidentally happens. So the only thing I'm asking you to do is do not go to the leasing office. Don't call over there because the problem is what if she's there and she answers the phone? I'm sure that you may have other friends, other persons that can help you out if you need to get in contact with the leasing office. But at this point, I just don't think it's a good idea for you to have contact with them. She can go back to the house, just don't go to there and don't have contact with this person. Sure.
Okay, somebody came and knocked on my door yesterday, and they said that, well, I got a phone call first. I think they were somebody, I didn't even really pay attention, I was like, oh, yeah, I need to station. You know, where it's at. Yeah. And then there's your name, but I don't know, watch out. Watch out. After that, they came and knocked on my door and wanted to talk to me. I said, no, I can't talk to you.
Okay.
And so can they not bother me either?
So I don't know about that. The only thing I'm saying is that don't want you to have contact with this person. If this person should call you, don't answer the phone. If they contact you, don't reply. There are other people there at the leasing office. They should be able to talk to you at a minimum. Perhaps Ms. Henley can reach out to them, go, look, we've got this case, we've got bond conditions. If you guys need to talk to Ms. Bahana, please have it someone other than this complaining witness so that they know not to.
But this, doing it together. It's not just her, and it's not true what they said about.
Okay, well, it's okay, but that's why we try to separate you because we don't want more unhappiness to occur. I'm sure Ms. Henley can help you out with this, or perhaps if you have a friend, that friend can reach out to the leasing office and go, hey, look, it's probably not a good idea for this complaining witness and Ms. Bahana to have contact. If you guys need to reach her, please have someone else that works at the leasing office do it. I mean, in every case where there is an assault that has occurred allegedly, we always put the conditions on that the person who is charged doesn't have contact with the complaining witness because it's just a recipe for disaster otherwise. Okay? All right. I don't know. I wasn't there. The evidence will point to whose side is correct because that's what we do. We work on evidence here, and whether there's video, whether there's other witnesses present, that really kind of dictates how the bus gets driven. Okay? You've got a great lawyer here. Listen, Ms. Henley, she'll take care of you. Okay? All right. Thank you. Okay. Are you ready?
Yes, Judge. I'm here with Ms. Watson, Shanti Watson.
Okay. Come up, Ms. Watson. So she was ordered to get the device.
Correct. She's a judge, and before we begin, she's a resident of the state of Maryland. She's been living in Maryland since before this case was filed. And I believe that is one of the reasons one of those other DDOs was also filed. There's a bunch of legislation that arise when someone is being monitored by pretrial services and they live out of state. And I think this is one of those issues. This is also a result of that. There's no shipping location. So there's no pickup location within 600 miles of where she resides. So unless she were to have stayed here for a full 2 weeks, she has no ties to the state of Texas. Where she can stay here to wait for a device to be shipped out to her here. So she provided a family member's address. That device was to be shipped out to a family member's address, and they were then going to provide it to her. There was a delay in this device being sent out to her. Which is why we are here today. She informed me promptly as soon as she knew that she was not going to be getting this device in time. I then emailed pretrial services. They've also been in contact with the vendor who also confirmed that there was a delay in the device being shipped out. So to this day, she does not have the funds.
So she was ordered to get the device by
She was ordered on
1, 2, 3, 4, 5, 6, 7 by the 3rd of July, right? When did she request the device?
She went to pretrial services the same day because she had to catch a flight back to Maryland that same day right after court. In fact, she caught a flight from Maryland to Texas this morning. So she went to pretrial services that same day. They then told her that she had to reach out to Smart Start, then had to ship the device out to her, and she promptly did.
No. Probably. When did she reach out to Smart Start?
That may be correct.
I think it's mentioned, you supposed to come on the 3rd. I heard the message. I have the message that said when it was supposed to be shipped, but it was.
No. My question is, when did you reach out to Smart Start to let them know, hey, I need a device? On the 3rd.
No, not the 3rd. I was supposed to have it on the 3rd. That's.
Oh, I'm sorry.
Yeah.
So what, you telling me on the 17th, I'm sorry, on June 26th?
Yes, I called them.
And they said that it was supposed to come on July 3rd, which is the date that pretrial services told me to happen, but it was shipping delay on UPS. It said that they put in the wrong address.
Do you see that, Michael? So she requested the device on 26th of June?
The suppliers didn't have the boxes, they were back in the minutes, so that's the reason why.
But she did request it on that day, on the 26th.
Yes.
Okay, as long as you can confirm that. How long have you been on this case?
It's only been, I say since June.
Let's see.
She had previously hired counsel, they withdrew, I was appointed to the case.
You were appointed on the 26th, that same
So
day.
many things that we can do on this matter, even if she were to be acceptable to PWI PTI, given that she's a resident of the state of Maryland, no one's gonna trust her supervision. And same goes for, I haven't gotten enough CLO, but I'm pretty sure the blanket rule is that you can't transfer first-time DWIs to another state.
I don't think they recognize regular probation, but I don't think they would recognize PTI programs.
Before you hear on this BCR, the state has offered her a snipe search. Ms. Watson has indicated that she would like.
Is that what you want to do?
Yes, sir.
Okay, then, yeah, by all means. It's up to you. That would kill everything.
Yeah.
But that's up to you guys and whether that's something that you want to do. Yeah, the diversion program is a creature of Harris County and not other. I mean, I don't know how many other jurisdictions recognize something like that. I don't know. So I'll let you guys meet. I won't take action and I'll continue supervision. If,
Is in your key.
oh, you ready?
Yeah.
Oh, Ms. Watson, you're charged with driving while intoxicated. It is elevated to a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement. They're offering you 3 days in jail with credit for the 3 days that you've done. You need to understand something important. This DWI will go on your record. The full faith and credit clause of the Constitution means that other states recognize things from other states, whether it may be a conviction, whether it may be a license suspension. So you need to be careful. You get pulled over, officers see a prior DWI. If they come up to you and they smell something or you understand?
Yes, sir.
From now on, you pick up any more DWIs, it's a minimum of 90 days in jail. You are giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this. If you are on probation or parole, pleading guilty to this you can be revoked, resulting in further confinement. Is this what you want to do?
Yes.
How do you plead to the offense, man? I'm going to find you guilty. I'll follow the agreement. I'm going to roll your forecast so you won't owe anything. But I will tell you, if you pick up a second DWI, a conviction, it's a $6,000 surcharge. And if you don't pay it, every $100 that you owe, you sit 1 day in jail. So be very careful. All right. Good luck, man. Oh, I have to suspend your license. I'm going to do it for the minimum, which is 90 days. And good luck to you.
And I do have one more matter.
You're almost there.
This is on Mr. Smith's judge. He also has a BDR. There was a new law violation on a POM case.
Is he here?
He is, and I'm not sure if you've already heard PC on the POM, but I would like to hear it on time.
Okay. Derek Smith, come up. Mr. Smith, you are charged now with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On July 10th of 2026, an officer did a traffic stop where the defendant was operating a vehicle with obscured plates, and
with what?
Obscured plates.
Obscured plates. Okay.
And in Harris County on a public roadway, once the traffic stop was initiated, the officer smelled a strong smell of marijuana, and the defendant stated that he had a dime bag of marijuana underneath his seat. The officer found it, and it was 2.2 grams, equal to 0.07 ounces. The marijuana is also against defendant's bond conditions. There was another passenger in the car who said it was not his.
Judge, the issue here, I believe, is the officer.
Wait, I didn't hear.
The stop itself, the officer mentions obscured license plate on the vehicle. I'm not sure in which manner or way they're obscured. He doesn't indicate exactly what makes them obscured. There's no indication that a number or a letter on the license plate itself was not hidden, but he could have determined what the license plate number on this vehicle was. I don't think that there's enough here.
I would just say that he's saying it's obscured and she's saying it's not obscured. That's a matter of fact.
Yeah, I think that there's enough probable cause to go forward. Mr. Smith, you've now picked up a new case. You were ordered not to pick up any new cases. I now have to revoke your bond, sir. You will go into custody. As a condition of your bond, you're ordered not to consume alcohol or illegal drugs. You will be tested 50 days from today. If you continue, then I'm not asking much from you. I told, don't pick up any new cases, Mr. Smith, really. Just, no buts. Just don't pick up. Okay. It's 5,001. I will leave the weed case as is. I'm not going to touch it, but 5,001 on the other one. Thanks. Hey, all right, Mr. Goins, thank you for being patient.
I'm here on Mr. Angel Amaya. Please, mom.
Amaya, come up. Good morning, Mr. Amaya.
Good morning, sir.
Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
On July 11th, 2026, an officer was dispatched to the reported family disturbance at 5427 Fairways Forest Drive, which is in Harris County, Texas. Upon arrival, the defendant was in handcuffs in the rear seat of a marked patrol vehicle, and a witness who stated she was in a dating relationship with the defendant. The complaining witness is the witness's mother. The complaining witness arrived at the residence and observed the defendant outside with witness's belongings placed near the front door. The complaining witness repeatedly told the defendant to leave, but he refused to do so until witness sent defendant money. As witness tried to enter the residence, and a verbal altercation began with the defendant, and defendant attempted to force his way inside. Once he forced his way inside, he grabbed the witness by her arm, resulting in a scratch. The complaining witness attempted to close the door when the defendant grabbed the complaining witness's wrist, causing bruising and visible marks. Then the defendant shoved the complaining witness's face with an open hand to prevent the complaining witness from closing the door. After Miranda was read, the defendant voluntarily admitted to grabbing witness by the wrist and shoving complaining witness's face with an open hand.
So that's on one case. He has an assault as well. I just noticed that he's also charged with assault bodily injury. Is there a second complaining witness?
There's an assault of a family member, and there's a assault of causing bodily injury, but I believe, let me just double check, it's really from the same set of sections, because he shoved the witness in. I think it's the bodily injury from the mouth. Yeah.
So the second one is the mom, because which part was that one? I didn't.
So it looks like he grabbed one of them by their arm.
Okay, so that's the assault where he grabs and then ends up bruising.
No, that's the girl, that's the AFM. And then the mother would be, she shoved her with an open hand and closing the door.
Got it. Okay. Mr. Amaya, I'm going to find that there's sufficient probable cause to go forward on both of your cases. As a condition of your bond, you were ordered not to have any contact with either of the complaining witnesses and not to be in possession of any weapons. If you do, I will revoke your bond to put you in jail. I will protect my community at all costs. I don't care how old you are. I don't care what color you are. You endanger it. It's just not going to go well for you. Do you understand? You are also not to be in possession of any weapons as well. There is a protective order that has been issued in the family member case. You need to get to know it. If you violate the protective order, they can file additional cases against you. And it's one of the worst cases you can pick up in misdemeanor court. Do you understand? You just make sure that the MOAP has no contact. All right. Guys, do you mind filing conditions on Mr. Amaya, no contact, no weapons, so it outlives the MOAB on both cases, please?
Yes, Judge.
Okay, all right, I'm gonna have you sign a reset. We will have you take a seat in the jury box where we get your bond conditions. Once you sign them, at that point, you'll be free to go. Thank you, Mr. Goins. Okay, are you ready, guys?
Yes, Your Honor.
I signed your conditions on last go, by the way.
The conditions weren't right. They were the same ones. They didn't say no threatening on that. They said no conflict and also there. I think the state is amending them now because they want to use.
Got it, okay.
Right now, we're approaching on Mr. Theriot. This is the case that got a little complex. They said right now, he's at the PDR phase of filing this discretionary review because he was kicked or denied by memo from the Board of Appeals.
Right.
So now the move is when Victoria's calling tomorrow the lawyer that's going to do both appellate and fugitive because I guess the PD's office no longer does the appellate work. So she's tomorrow to find someone that's certified.
Okay, I mean, it is what it is. Victoria.
I could appeal the county for this category. You don't decide that.
But really, Mr. Johnson, it is what it is. You know, if you want to do the PDR, then you can do the PDR. It's up to you. You do what you need to do. If you want to do the PDR, then you can do it. Hey, do we gonna find someone to do the PDR one?
Down to Shamarla, and she can call Portia.
Okay, there we go.
So roll it for Monday then, because there's timing and I don't want to lose time.
Yeah, that's fair enough. I'll talk to Portia.
Yeah, okay.
Not my first option, but maybe I can.
Okay, just let me know. You're Mr. Green. All right, good morning, Mr. Green. Sir, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 20 days in jail with credit for the 8 days that you've done. You were giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers if you are not a citizen. There are possible immigration consequences. You can be deported, excluded from the country, deny naturalization. You give up the right to appeal. You just got arrested on this. Are you sure you want to do this? Have you had enough time to do anything on the case?
I've had the opportunity to review the evidence available in this case and the probable cause. The issue here is that he already has a PR bond for this, but he has a hold out of Louisiana extradited in order to.
Got it. Okay. So I don't know if you're on probation or parole. By pleading guilty to this, it may revoke that probation or parole because I have just no idea. Do you understand?
Yes, sir.
Knowing this, do you still want to do this?
Yes, sir.
How do you plead to the theft? Guilty or not guilty? I'm going to find you guilty. I'll follow the agreement, send you to 20 days in jail, give you credit for the 8 days that you've done. I will roll your court costs so you won't owe anything. And that's it. Okay. Thank you, Mr. Green. Yeah. Tell me.
Okay, the first one is going to be 259.
Okay.
8082.
8082 on Rick's.
Yes. So she completed her probation.
She has a warrant.
Exactly. So we just found it happened on the same day. So this day she completed the probation on 7/15. They filed a 2B warrant for a theft charge from before, but it happened on the same day. So they're asking you on the onset of her asset term. Technically, she completed everything. She got her GED, was engaged in mental health treatment, did anger management. She was reporting and she just picked up.
God dang. I mean, really. I mean,
I know. I know.
You're doing so damn good. You even get your GED and now you're done. I mean.
Yeah. And we just found out yesterday. We can't do a motion because.
Yeah, I mean,
It's
that firm.
Okay.
I mean, she did all that. It's great. It just sucks that she did. But
The
okay.
next one is 187.
Dang. Okay.
8997. So she absconded all the way back in 2014. She just picked up a new charge for possession in Arlington. On her extradition warrant, it's limited to 200 miles. So they're asking if they want to change the warrant so they can keep her. So there's kind of a guess we'll go get her because the warrant is a limited miles. I've never heard of it.
So it's, hey, we need to, so typically what happens is when she has an out of county with one of our probationers.
Yes.
So the 10-day rule would apply in that, wouldn't it? So usually Harris County has 10 days to go pick her up, but because it's far, they're not gonna go pick her up. So in 10 days, they're gonna release her.
Okay.
I'm not gonna give her a PR bond. I mean, I'm not gonna reinstate the bond when she's been gone for 13 years.
A long time.
No, she'll just have to, at some point, if she doesn't come back, she'll at some point get popped, continue to get popped on it.
Okay. Then the next one is 257
Hold on. 257.
6614.
Okay,
He tested positive for THC, med, and.
Issue warrant.
Okay.
it's 15,002 now, so 20,003.
And the probation officer wants him to be at 650.
Oh,
And then the last one is
or wait, should we do a court march?
Well, we can admonish him,
Yeah.
and then I can take them into custody. of it. Mhm. Okay. Okay.
And then if he blows the court admonishment, then we'll.
Issue a warrant. 256
Okay,
3080.
okay,
So he's supposed to get on probation September 22nd. He tested positive for cocaine twice. His last UA on the 13th was negative. He said he was having marriage problems and that's why he did it. I wanted to do a relapse SOP and then he has about $1,500 left for paying his court costs. So they want to extend him with non-sham after do relapse. SOP.
has he been extended before?
Yeah.
Man, how are you gonna say I had marriage problems, so here, let me go do some cocaine?
I know.
Maybe that's the creation of the miracle.
Mhm. But he's completed all of his classes, through victim impact panels, EWI, repeat offender scores.
Okay, all right, I guess we'll do that, we'll see.
Okay.
But I want weekly tests.
Hopefully that's,
Yeah.
okay. So then that's it.
Okay, thanks, Shatar. Do you really want to go to jail, Mr. Mondragon?
No.
Your alleged actions tell me differently. I am now going to place a scram device on your ankle, and it will detect alcohol through the perspiration in your skin. I don't give a rat's behind what your next excuse is. It is absolute no tolerance. If you test positive for anything, and I don't care what it is,
It's his leg monitor, Judge.
if you test positive for anything else, you will go to jail. Do you understand me? You better know darn well what you put in your body from now on. I don't care whether it's mouthwash. I don't care whether it's toothpaste. If it's hair dye, whatever excuse you may have for testing positive for alcohol will not fly. You understand? Okay, I will have you meet with pretrial services. We will give you another 30 days. When you come back, please have a lawyer. Oh. Oh. Hey, are you ready? Look at your list. Watch your head, love.
Bottom of 5 is, the
8,001. And let me do a VR on that too.
bottom of 17. Except for Raymond fell to appear first time.
2501. Mr. Vaughn, talk to me.
I have a docket matter.
Okay.
I need your guidance on cause number 2627130.
Sokolov,
Yes.
okay?
Her license is suspended, because of, I believe, like traffic tickets, car accident, something like that.
Okay,
And she also clocked the DWI on your court. And you say that do not drive unless you have a valid driver license. This is our question. Can she apply for an occupational license?
I don't know.
Is your,
Anybody can apply. I mean, theoretically, anybody can apply. Will it be granted? That's a better question. Does she have a license? Is it expired? You know, I don't know. What do you see? Is it suspended? Is it canceled? Is it revoked? Is it?
I'm seeing that it's suspended. Its status to be reissued. It's not eligible. The last suspension date was supposed to have been lifted in 2025, but it's
What was it suspended for?
driving without a license.
Did you see a DWI or a DWLI? I don't hear. It's not, when it's not with us, it's got to be somewhere else.
It's not.
There's traffic.
But it does say into Texas.
she also got suspended, Your Honor, because she had an accident a long time ago and she don't have insurance. There's a judgment on it.
So what she's going to have to do is she'll have to get multiple SR 22s or multiple SRs. Definitely an SR 22. There may be another SR that she's going to need. Let's do this. Do you have the number to the DPS, the driver license division? Hey, are you guys waiting on us? We're done. Go. We're done. Sorry, guys. I didn't realize it till just now. Yeah. Thanks. Have a great weekend, guys. This is the driver's license division for DPS.
Thank you.
Call at 7 a.m. And what I would do is I would ask them, hey, or either you or her, whoever, say, hey, look, we want to apply for an occupational license. Is there anything that we're going to need? I can give you an occupational license, whether DPS extends it for how that's up to them. And you have to meet certain requirements. She may have to pay the reinstatement fee. She may need to get multiple SRs. I don't know. Have them call, see what they say, and then let's talk about it. And I'm happy to give you one, but there's no point in giving you one if they're not going to honor it. Because our order is only good for a certain amount of time. I think 30 days. After that, it's up to DPS to extend it. And so let me know.
Thank you, Your Honor.
Yeah. Mr. Long, coming up.
May we approach, Your Honor?
Yeah, for sure.
Thank you for your patience.
Please, it's not a big deal. You know, Mr. Long, we want the best thing for you. You already, we can never put ourselves in your shoes. You will have a very hard time living in a society I don't know if you keep up with the news, if you keep up with current events. Life can be very difficult. Life can be very difficult for all types of people. When you end up with convictions, when you end up with criminal cases, all you're doing is you're making just life more difficult when it already is difficult. It's not easy. This life is about one thing. It's about money. And if you have money, this life is so freaking fantastic. It's so great. The vacations you can take, the nice cars that you can have, the great places you can go eat, just nice clothes, everything is great. But it all starts right here. It starts with an education. It doesn't start ending up in criminal court with violation after violation. Just nothing good happens for a 17-year-old at 1 a.m, especially when you're on bond for a criminal case. You either going to learn this the easy way or you're going to learn it the hard way. It's up to you how this happens. Me, I'm still going to go home. I'm still going to earn my monthly paycheck. We want the best for you. What you're doing now, you're only hurting yourself as your future grows, because your future is either going to go this way or it's going to go that way. And this way sucks. If you don't believe me, start asking around. Ask friends who have convictions how hard it is to get a job If you become a felon, it's freaking over. Really, it's just damn near impossible to get a good job. No one hires thieves. No one hires felons. Do you understand? You're charged with evading arrest or detention. The agreement that you have worked out is a 9-month deferred. If this is a type of probation that if you complete successfully, there's no conviction on your record. You need to understand something very important. The case does not get dismissed if you complete this successfully. You just do not end up with a conviction. There's a big difference. Do you understand? If you complete this successfully, if you do finish the deferred, at some point you can even have this thing sealed so that the general public cannot see this. That's the goal here. The goal is that you make this out in one piece, stop ending up here, because really it's not. Tell me what you're doing with yourself these days. Did you quit high school? Are you in high school now? Did you graduate from high school? So did you quit high school? People who at a minimum don't have a high school education will make pennies to when everybody else is making $1. Telling you, you are headed in the wrong direction. Nothing good is happening for you now. You need to really shape up, because otherwise you're going to have a very hard life, Mr. Long. For you to complete this successfully, you must do a Thinking for a Change program. You must do a random drug testing, no drugs, no alcohol, 12 hours of community service, and the GED program. You will get your GED. And let me tell you something. I can keep you here for the next 2 years, maybe 3, who knows how long, and I'm going to keep you until you get your GED. I don't care what damn excuse you have. If you start playing games, I have the authority. They can file a motion to revoke. We can have a hearing. I can put you in jail, leave you in there for a weekend, let you out, see how you do. You start toying again, next time, maybe a week. Next time after that, maybe 2 weeks. If you start toying with us, I'll make you a deal. You get the class done, you get your GED, I'll take you off. This deferred all depends on you. The minute you get this class done, the minute you get your GED, I'll take you off. But if you start playing, it's just not going to go well for you. And chances are your mom, being a single mother, like what she's saying, she doesn't have a lot of money. She's probably just trying to, like all of us, just get by. And when you end up in jail with a $10,000, $20,000 bond, you think she has that kind of money to pay for you? Make the right decision. I'm telling you, you're going to get tested for drugs and alcohol. It's not a matter of if, it's a matter of when. You understand? Test in a couple weeks, please. They're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. You are stuck with this until you complete it successfully or it gets revoked. If you start playing, they will file a motion to revoke. I will sign it. You will go into custody. We will have a hearing to determine if you violated this agreement. If you do, you are looking at a solid year in jail. But I'm telling you now, we will work this thing until you get your GED. You understand? Mom, as long as he's enrolled in this program, I'll waive the community service, take off all the fines and fees. There are no firearms. You are not allowed to have any kind of weapons or ammunition. Do you understand? Is he currently enrolled now in a GED program?
Yes, he goes to HCC. He's been enrolled there for what, a month?
Wonderful.
A month and a half.
How
So
long?
he's getting ready to start testing. They have 2 separate, he took the first half of the class, So he's now in the second half of the class. So once he completes the 40 hours for that class, he
Okay,
can go and get tested.
okay. So how long do you anticipate to being done?
They said 3 weeks, 3 to 4 weeks.
That's it.
Yes, yes. 3 to 4 weeks that class will be complete and he can go for his testing.
Okay.
Yes.
One more thing. What do you want to do with the rest of your life?
Speak up.
If you had your dream job, if you could do whatever you wanted to do, what would you want to do? Really? That would be a great profession. What's stopping you? They need firefighters and it's a great profession. You know, if you have nothing to do, you know, you can join the service. That's something will help you out. They will help you pay for school as well. But you can do firefighting. That'd be great. All you have to do is finish here, get your GED and start looking and all you have to do is apply. I mean, when you put your heart into it, you can do damn near anything in this life, really. It's just a matter of, do you really want to do it? If you do, how much do you want it? You know, I'll tell you, and I don't think I've ever told anyone this before. I was a big screw-off in high school. I was so bad and I skipped so much classes. I nearly failed every single class in my freshman year. I was such an a-hole to my teachers that they would have flunked me, but they didn't like me and they hated me so much. They said, no. Put that dude in sophomore year because we just don't want him anymore. And it took me really having someone put me under and show me, dude, what the hell are you doing? And I worked my ass to get where I am now. And what it took for me was a change of environment because where I was, who I was with, and what I was doing. I mean, the people that I know now, one's dead, another one is working construction, making just, you know, and it took me a long time because I lost probably 2 to 3 years of my high school. And so for me to get into college and then into law school, it was so much harder for me just because I didn't have that background. But if you have the heart and you have the will, because I do, and no one's going to tell me any different and no one's going to ever stop me. I mean, you got that, you can achieve damn near anything for so long. You understand?
Sure.
Okay, man. Make me proud. Okay. Thanks, guys.
Thank you for pushing him.
What I'm telling you, you start screwing around, I'm just going to throw your ass in jail. That's all that's going to happen. I mean, and I'll do it over and I'll do it over. And we've done it before. I've kept people here for what, 2-3 years until they shape up and fly right. If that's what we got to do, then that's what we got to do. So it's up to you how soon this thing ends and how soon it goes. All right. Thanks, Mom. Thank you.
I'm ready.
All right. You too, guys. Take care. Thank you. We're done.
Thank you. Steps Beta.
Oh, you're gonna rate it on Sepulveda, Your Honor?
Oh, Sepulveda. Sepulveda, come up. Did I give you the document? Sorry, I thought it was wishful thinking. Mr. Sepulveda, you're charged with driving while intoxicated. You have not picked up another case. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay.
Your Honor, Mr. Sepulveda was found driving on a public roadway. The officer observed his vehicle crossing over double yellow center lane dividers, continued watching his vehicle traveling westbound on the feeder road, observed the vehicle failed to signal 2 lane changes as it continued, failed to maintain a single lane of travel with other vehicles on the road. They were able to see that the vehicle he was driving had a temporary license plate that showed it had expired June 7th of 2026. The officer observed this on July 11th of 2026. Once they conducted a traffic stop on the vehicle, they observed Mr. Sepulveda to have slurred speech, red glossy eyes, and an odor of alcoholic beverage from his breath. He then stated to officers that he had consumed 2 beers within the last 4 hours. They conducted HGN and found 6 out of 6 clues, but Mr. Sepulveda refused the others. They read DIC and he refused to give a sample, so a warrant was executed.
Does he have a license to drive?
I apologize, Your Honor. Let me run that really quick.
And then does he have any prior DWIs from any other jurisdictions? Oh, he does. He just had one dismissed.
County, but it was dismissed.
Mr. Sepulveda, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using alcohol or illegal drugs, I will revoke your bond and put you in jail. As it stands now, I'm ordering you not to drive any vehicle that's not equipped with an ignition interlock on it.
He does have an eligible.
It's eligible? Okay. Now, you are on bond. You have picked up a new case. We will have a hearing on Wednesday on the bond violation that you have picked up now. So I'm going to set your case for Wednesday. You must be here with your lawyer, and we will have a hearing on your motion to revoke or on the bond violation. Do you understand?
Sir.
Okay. We're going to be signed. We'll have you reset to Wednesday. And yeah, we need a guardian interlock on, please. Okay, great. Ms. Hudson.
Good morning, Judge.
Hey, good morning.
I'm approaching on Mr. Simon, Kobe Simon. It's an off docket case. I have the case number when you're ready.
I think, didn't we talk about that with someone already today?
Yes, my colleague approached this morning for me.
Okay, what's the cause number?
260-7615.
Okay. Oh, this is the guy that's working offshore.
Yes. But I mean, the court, they were aware that he works offshore already. What happened previously was he was supposed to provide his schedule. And so they told, according to him, they told him that he could provide his schedule up to 3 months in advance. So the last date that they have is May. And I know like 3 months passed, so he probably just forgot to update his schedule. I did send that updated schedule to pretrial services this morning. And so I don't think it's an issue with him using or anything like that. It's simply just 3 months passed and he forgot to send his new updated schedule for the next 3 months. And so if he's not able to take a test today and then they send the bond violation and you require him to come next week, he won't be able to. He's literally on the boat. He comes back on the 28th, I believe.
Of this month?
Yes, sir.
Okay, so let's set him for the 29th.
Okay. Okay.
But if a bond violation has occurred, it needs to be filed though.
Okay. Understood. I just don't want him to be set for next week and then he gets a bond forfeiture or something like that, knowing he can't come next week.
Michael, can I give you a cause number, please?
There you go. See you on Tuesday or Wednesday.
2607-615. Mr. Simon, we spoke about this earlier. So Mr. Simon is supposed to provide pretrial services schedules of his work so that they know when he's gone and when he's not gone. He did not provide the latest schedule, or he may have, I don't know. If there is a bond violation, though, a bond violation report needs to be filed because he's supposed to live up to certain conditions. If he's not doing that, then a bond report needs to be filed. Please, just make a note of it. And in your infinite wisdom, if you see that a bond violation has occurred by not being able to test, not doing this, not telling when he's supposed to be here, please file it and then we'll address it. As far as when we will set him, if there is a bond violation, Ms. Hudson, we will set him for the 28th of this month.
Okay. Thank you, Your Honor.
Victoria, did you get the cause number on that?
Yeah, sure.
It's 2607-615. This dude works on an offshore boat and he's supposed to provide his work schedule so he doesn't get called. And I don't think he has done that. So pretrial services called and he's not been able to come to take a test because he's gone elsewhere. I told him to file a bond violation report. He's still on the boat until the 28th, I think she said. Or
Yes,
20.
sir.
What day?
The 28th.
28th. So I would say maybe put him on the 29th or 30th just in case, and then we can address it at that point. All right, Ms. Hudson.
Thank you, Your Honor.
Okay, take care.
You too. Bye-bye.
Bye. Okay, we're done. Thank you so much for the help.